Dear listeners, welcome back to the Lawyer Talk, the podcast channel of BLawyers Vietnam. I am Quang Thai, and joining me today is Thu. We are very happy to see everyone again in today's podcast. Continuing the topic on due diligence of intellectual properties in M&A transaction of technology companies in Vietnam. Today, Mr. and I will share two special cases that enterprises investors may encounter during the due diligence of intellectual properties in technology companies.
Hello, Mr. Thai and listener. I am Anh Thu and very glad to join you in today's podcast. I hope that today's topic will help our dear listener identify best cases, thereby allowing you to grasp the issue, to know when implementing the due diligence of intellectual property in technology companies. The first special case is a content that Mr. Thai mentioned in the reverse podcast expo. Specifically, when conducting due diligence of intellectual property in a technology company, the enterprises investor should reveal the status and motives and current history of such intellectual property. So how does a particular intellectual property become a collateral? Mr. Thai, please answer the question.
First of all, I can confirm that an intellectual property cannot become a collateral under Vietnamese law. Specifically, Article 105 of the Civil Code 2015 stipulates that property includes objects, money, valuable papers, and property rights. Among these, property rights are rights which are able to be valued in money, including property right to subject of intellectual property rights, right to use land, or other property rights. Based on this, the intellectual property itself cannot be considered as a collateral. Only the property rights to subject of intellectual property rights can identify as property, thus may become collateral. For example, the right to use or allow others to use a trademark is the property right which can be used as collateral to perform obligations.
I am not clear to which type of property right to subject of intellectual property right may be used a collateral under Vietnamese law. Mr. Thai, please explain more about this.
Yes, to help our listeners and to follow more easily, I would like to share two types of collateral which are property rights to subject of intellectual property rights. The first type is the property right to subject of copyright, such as computer program and data collections owned by technology companies. Specifically, the IP law stipulates that the owner of copyrights of computer program data collections had the right to transfer ownership of, first of all, property rights to computer program data collections, and second, right to publish or allow others to publish computer program and data collection to other organizations and individuals pursuant to a contract or in accordance with a relevant provision of law. On this basis of being able to transfer these property rights, the technology companies can completely use these property rights as collateral to perform their obligations. The second type of collateral is property rights to subject of industrial property rights, which are patents, industrial design, layout design, trademark, trade names, trade secret. Accordingly, the IP law stipulates that the owner of industrial property rights had the right to transfer their ownership rights to another organizations or individuals within the scope of protection. However, it should be noted that the transfer of industrial property rights must be satisfy specific conditions as prescribed by the IP Law 2022. For example, a trademark can only be transferred to an organization or individuals who meet the condition for person having the rights to register that trademark. Therefore, the secured parties must satisfy the above condition for trademark to become a collateral and be able to enforce the handling of the collateral later.
Yes, I have questions. With two types of collateral that you just mentioned, what should enterprise investor pay attention to when conducting due diligence in M&A transactions?
In addition to the content that enterprises, investors need to pay attention to when assessing intellectual properties that we mentioned in the previous podcast episode, I would like to propose some more content for listeners to consider in the case a target technologies company, or also called as a target company, using property rights to subject up intellectual property rights as collateral. First, enterprise investors still need to check the industrial property protection title and copyright registration status. Ensure that the target company is the owner of the intellectual property rights, as well as check the scope, protection period, and the validity of the protection title. Secondly, review the list of property rights to subject up intellectual property rights being used as collateral, including checking the validity of the guarantee agreement, notarizes or not, the content of the secure obligations, and the agreement on handling collateral in case of violation. At the same time, verify the registration of the guarantee agreement to assess the validity against the third parties. Next, consider the possibilities of transferring intellectual properties which have property rights used as collateral to enterprise investors after M&A transactions, as well as the transfer condition according to the provision of IP Law 2022. Finally, check and evaluate the risk of dispute with the secured parties or with other related parties related to the collateral being property rights to subject up intellectual property rights.
Thank you, Mr. Thai, for explaining my concerns. I think that the bold sharing has helped us better understand the content to note when conducting due diligence in cases where the target company had intellectual property used as collateral. And as Mr. Thai introduced at the beginning of the podcast, besides this case, there is another special situation that the enterprise investor needs to pay special attention to, which is when intellectual property is created by the target company employees or contractors.
Yes, this is also a very common case in practice, but is easily overlooked during the due diligence. So in this case, what should we pay attention to when conducting due diligence? Please share more about this.
First of all, I think it's necessary to affirm that subjects of intellectual property rights, such as invention, industrial design, work such as computer program, data collection, etc., are all directly created by individual or group of individuals. So if that creative process takes place in the form of a task assigned by a technology company, for example, the company invests funds, provide facility, and assign work to employees of the technology company, or hire a creative contractor, then will the intellectual property right belong to that company or the individual who directly created? To answer this question, we need to first learn the provision of the IP Law 2022 on this particular case. For the creation of computer program data collection protected in the form of literary work, the technology company owns the right to publish or allow order to publish the computer program and data communication in the following cases. First, the technology company assigns the task of creating computer program data collection to creators who are employees of technology company, or second, the technology company enter into contract with the creator of the computer program collecting data. In the two cases I just mentioned, the direct creator, whether employee or contractor, will enjoy moral right to the computer program they create, including first, giving title to the computer program. Second, attaching their real name or pseudonym to the computer's program, being had their real name or pseudonym acknowledged when the computer program are published or used. Thirdly, protecting the integrity of the computer program to forbid other persons to modify, edit, or distort the computer program, causing harm to the honor and reputation of the direct creators.
Thank you, Smith Thu. I note two cases as you mentioned and three moral rights over computer program by direct creators. whether it's by employees or by the contractors. So, for intellectual property such as patent or industrial design, do these intellectual properties confer any moral or property rights on the individuals who directly created them?
Lee, allow me to explain more about this issue. For intellectual property such as invention, industrial design, and layout design, technology company had the right to register for protection to become the owner of such intellectual property objects when inventing funds and material means for the direct creator in the form of job assignment or hiring. Accordingly, owner of invention, industrial design, or layout design in this case is technology company that is granted protection title for respective intellectual property object by the competent authorities, although not as deeply personal as the literary and artist work. Individuals who directly created invention, industrial design, and layout design are still recognized as the creator and have the following moral rights. Firstly, to be named as creator in the invention patent, utility solution patent, industrial design patent or certificate of physics design or semiconducting closed circuits. Secondly, to be acknowledged as creator in document in which invention, industrial design, or layout design are published or introduced. In addition, the direct creator are also entitled to receive remuneration from the technology company as agreed between the parties. The IP Law 2022 specified the remuneration level as follows. Firstly, creators are entitled to receive 10% of the profit gained from the owner from the use of the invention, industrial design, or layout design. Next, creators are entitled to receive 50% of the total amount received by the owner in its payment for licensing of the invention, industrial design, or layout design before paying the tax in accordance with the regulations.
I have one more issue regarding the special case that you just mentioned. What should enterprise investor pay attention to when conducting due diligence of intellectual properties?
In this particular case, I suggest the enterprise investor consider the following content. First, it is necessary to identify the combined invention, industrial design or layout design, computer program, and data collection owned by the target company that were created by employee and or contractor. Next, it is necessary to list and review documents recording the assignment of the creation of invention, industrial design, layout design, computer program, and data collection between the target company and employee contractor. For example, employment contract, job description, and contractor agreements. It is also important to examine the internal regulation and agreement regarding remuneration for creator of invention, industrial design, layout design, computer program, and data collection of the target company, as well as the actual payment of such remuneration of the individual who directly created the intellectual property. Finally, it is necessary to make a list of disputes that occurring related to the creation of intellectual property by employee and contractors, such as the payment of remuneration, if any. When considering the content that I have just presented, I think that enterprise investor will minimize the many risks more accurately assess to the value of the target company. From there, they can make a more appropriate decision in their M&A transaction.
Thank you, Ms. Thu, for sharing our listeners the thing to keep in mind when conducting due diligence intellectual properties in this particular case. Dear listeners, we have passed the final stage of the topic due diligence of intellectual properties in M&A transaction of technology companies in Vietnam. I hope this has brought you a lot of useful information. If you have any question or concern, please leave a comment below. Or for more information about BLawyers Vietnam, please visit our website below the podcast screen of the Lawyer Talk. Goodbye and see you again.
Thank you for listening. Goodbye and see you again.